It finally happened. Something that I've been waiting for over 2 years now. Disney is suing Midjourney. That's right, the mouse has entered the chat, and we all know he does not around when it comes to his intellectual property. And whether you're team human or team algorithm, there's no debating that this could be one of the most influential copyright cases since Napster. Hell, it might even be the most important copyright case of our lifetime, because it's going to create a whole new litmus test for what is considered fair use, transformative, and whether even the idea of originality has any value anymore. Copyright laws in this country are always outdated, based on yesterday's technology. Even the laws that we have on the books today are still kind of rooted in a 90s world, based on print and analog. They still haven't quite caught up to the internet, so you know they are not ready for the shitstorm of AI slop content that's about to batter our digital shores. If nothing else, this lawsuit is going to provide a great opportunity for some much needed course correction in those laws, and of course, it's only fitting that Disney is once again cast in the role of white knight defender of intellectual property, even if it's guided by their own selfish, monopolistic interests. It's always Disney leading the charge in adapting copyright laws because, let's face it, they have the most to gain and to lose from it. They've built their empire out of intellectual property, and it is in their best interest to keep it out of the public's hands. And the irony is not lost on me that Disney built its entire empire off of the backs of intellectual property that was or is in the public domain. And then, of course, they fight like bloody hell to keep it out of the public's hands. I mean, talk about kicking the ladder down on your way up. But that doesn't invalidate their right to protect their lawful IP, and trust me, Midjourney is a shameless infringer, so you can be a hypocrite and still be on the right side of the law. Okay, so what's happening here? Both Disney and Universal Pictures are suing Midjourney for copyright infringement, bringing Hollywood into a war that artists have been fighting for a few years now. This is like a 250-pound heavyweight swinging haymakers for 12 rounds without ever getting tired. There ain't no Ali rope-a-dope defense here. You're gonna get hit at some point, and you're gonna get hit hard. We've seen time and time again in this country that you can win a lawsuit by drowning your opponent in legal fees. And in this case, Disney has both a legit complaint and the deepest pockets imaginable. This 110-page lawsuit contends that Midjourney helped itself to copyrighted works to train its software, which allows people to create images and soon videos that blatantly incorporate and copy Disney's and Universal's famous characters. Quote, Midjourney is the quintessential copyright-free writer and a bottomless pit of plagiarism, the company said in a lawsuit filed in the U.S. District Court of Los Angeles. Talk about shots fired. It goes further. The studios claim that generative AI theft is a problem that threatens to upend the bedrock of incentives of U.S. copyright law that drive American leadership in movies, television, and other creative arts, end quote. According to the most recent economic figures from the Motion Picture Association, the U.S. film and television business supports 2.3 million jobs and about $229 billion in annual wages. Like, this is a huge chunk of the economy that's being affected by the development of generative AI technologies. And we're not even talking about the other industries and white-collar and blue-collar jobs that are going to be upended and disrupted by this tech. We're just sticking to the arts. So, quote, we are bullish on the promise of AI technology and optimistic about how it can be used responsibly as a tool to further human creativity, Horacio Gutierrez, Disney's general counsel, said in an email. This is a New York Times article, by the way. But piracy is piracy, and the fact that it's done by an AI company does not make it any less infringing. Translation: we love AI, but only when we can use it to cut our labor costs by getting rid of our animators and VFX artists. We don't love it when the peasants get to use it. Tell me I'm wrong. It's worth mentioning that both Disney and Universal sent their own cease and desist letters to Midjourney last year, which were pretty much ignored except to acknowledge that they were received. And as of right now, you can still create Midjourney assets using their respective characters and intellectual property. So Midjourney is kind of just banking on the fact that, like, I mean, I don't even know what they're doing. They're pretty much just saying, like, come at me, bro. So what does Midjourney have to say for itself? Their entire defense rests on the doctrine of fair use. And fair use is a legal doctrine that allows you to use copyrighted works without the owner's permission within a certain context. And that context is usually for the purposes of parody, critique, commentary, education, news. It's not a free pass. It's a legal gray area. You're not entitled to it. You use it as a defense if anyone comes after you for using assets that you don't own. There are 4 factors to consider for something to qualify as fair use, and the biggest and most important one is purpose and character. Is it transformative? Are you adding new meaning? Are you giving it a new voice, a new context, making some kind of commentary? Or is it just a blatant, shameless, duplicate copy of the original? This is the dominant variable that Midjourney is using for their defense. They're claiming that their outputs are not copies, that they're actually new interpretations that transform the original meaning of whatever source material they're training from. To give you an example of a proper use of fair use, think of a YouTube video that wonders the accuracy of the Civil War South by playing clips of Gone with the Wind. Now, as long as those clips are short, 10 to 15 seconds, and they're filled with text overlays, voiceovers, commentary, critiques, and they're not just playing the movie front to end, that's generally going to be protected. No one's going to come after you for that. But courts have consistently ruled that parody is one of the strongest forms of fair use. You can borrow recognizable characters, settings, plots. You can mimic them as long as you're making some kind of commentary or social critique on the matter. So picture that episode of Family Guy where Stewie is dressed as Darth Vader when they parody Star Wars. Star Wars has been parodied a million freaking times. No one's gonna get sued for that. It also doesn't help if the original creator doesn't sue you, because apparently George Lucas was a big fan of that episode. But you would not be allowed to sell a t-shirt of Stewie dressed as Darth Vader without the proper merchandising license, and that's a very important distinction. The second variable is the nature of the copyrighted work, and things that are historical, factual, etc., they tend to have more flexibility when it comes to defending fair use versus things that are deliberately creative arts, which is the bulk of what Disney makes. Amount and sustainability. How much of the work was used? Was it just a sliver, or did you take its heart? And by the way, even a small amount can be too much if it's considered to be the heart of the product. So just imagine the first 10 seconds of the iconic John Williams score for Star Wars, right? Like that's like the part that everybody knows. Impact on the market. This one is huge. Does it affect the capacity of the original creator's ability to make money? Does it make people stop buying the original? This includes replacing the original, undercutting licensing fees, flooding the market with derivative cheap knockoffs, and intentionally causing any kind of confusion that would make people wonder whether something, for example, is a legitimate Disney product or a fake knockoff. And 10 minutes spent on Etsy or rummaging through LinkedIn job boards will tell you that's exactly what's happening here. And by the way, disrupting the market in itself is not illegal. Like, you're not gonna get in trouble for that, but you will if you're doing it by infringing on copyright. That's the key indicator here. And this is where the gloves come off, because we all know that Disney does not fuck around with their money. Someone making a YouTube video to discuss the accuracy of lightsaber combat in a galaxy far, far away as compared to medieval fencing is not going to stop someone from spending money to watch Star Wars, nor is it going to discourage them from spending money on merchandise. If anything, it might compel them to buy more. But AI generators like Midjourney are already deeply affecting the market. And while I'm not a lawyer or a legal scholar or anything like that, I don't think it takes one to understand that this defense is not going to hold up, and there's a lot at stake here. So going forward, everything I say here is just going to be my opinion, conjecture, predictions, but I think it's rooted on solid legal precedents, so let's get to it. Let's take a look at Harper & Row versus The Nation magazine, a Supreme Court case which set the precedent that market harm is the most important factor / variable when determining whether something is fair use, especially when it, quote, competes with or preempts the original. The court asserted in its majority opinion given by Sandra Day O'Connor, Justice O'Connor, that, quote, fair use is not a license to usurp the market. This was a massive landmark copyright case in which The Nation magazine got an advance copy of former President Gerald Ford's memoirs, which Harper & Row had the exclusive publishing rights to. And The Nation magazine posted a 300-word excerpt from the memoir, which it deemed newsworthy. But those 300 words were considered by the court to be the heart of the memoir, specifically because they contained the reasoning that Ford had for pardoning former President Richard Nixon, which at the time was like the tea that everybody wanted to be spilled. The majority opinion added that, quote, "The fair use doctrine is not a license for corporate theft, empowering a court to ignore a copyright whenever it determines the underlying work contains material of possible public importance." End quote. Quote, "To negate fair use, one need only show that if the challenged use should become widespread, it would adversely affect the potential market for the original." End quote. And in the case of AI, if you are automating what the original was intended to do, you're not transforming it, you're replacing it. Studios and small artists alike, like me, make their money by licensing their intellectual property, their art, their characters, their stories. And it can be for anything from home decor to selling products or services or selling merchandise. If Midjourney can automatically generate Disney or Disney-like assets with a simple prompt, you could argue, and Disney will, that the entire value of that license is now compromised, even when the outputs aren't exact one-to-one replicas. A client who might have paid Studio Ghibli to license their IP can now undermine the whole process for pennies. That is tangible market harm, and it is done without the consent of the original artist. Let's get something straight here. You can't copyright a style. Styles are not inherently protected, only final outputs are. Disney can copyright Mickey Mouse. They cannot copyright the animation style used to draw him. As a photographer, I own the copyright to every individual image I take, but I cannot own Rembrandt lighting or a specific color palette. People are free to reverse engineer art in the same way that we are free to reverse engineer the KFC original recipe, and we can open our own chicken restaurant with that recipe as long as we didn't, steal that recipe or bribe an employee for it. And the only thing that we cannot do is use KFC's trademarked assets to market it. So we can't use the same colors and fonts, we can't use their logo, we can't use Colonel Sanders, but we can make our own chicken restaurant using that recipe if we figured out how to make it on our own. That's not illegal. But if the assets are close enough and are capable of being mass produced, they could be considered derivative and infringing. So it'll be interesting to see what direction the court takes in this matter. And by the way, patents are the only thing that protect processes, but they are limited in time and scope. And things like recipes, which are trademark secrets, and creative arts, they don't qualify for that. So if you want to protect your process, make a medical drug. Visual styles are the core of many artists' work. You spend years developing a process, a tone, compositional elements, lighting, color theories, repeating characters and motifs. They are the essence of what makes someone stop and say, that is definitely a Greg Rutkowski painting if I've ever seen one. Rutkowski was one of the original ground zero, patient zero victims of massive AI generative theft. His dramatic and immersive paintings of fantasy elements, knights fighting dragons, etc., were copiously stolen and produced thousands, if not millions, of derivative copies from the internet. At some point, I think his name was used in more prompts than artists like Vincent van Gogh or Pablo Picasso. But he never gave consent for his work to be used to train these AI models. He was never compensated, credited, or properly licensed for it. But overnight, the market and the art communities were artificially inflated with cheap knockoffs of his work, possibly artificially lowering the value of his art. And as this technology progresses, it's going to get harder and harder to distinguish the fakes from the forgeries. In the eyes of Midjourney, someone like Rutkowski becomes nothing more than a texture or a vibe, a parameter in a prompt. His life's work is reduced to nothing more than style data for some tech bro's unearned instant gratification. So Disney can argue that if the courts don't act, more and more artists are going to become nothing more than ingredients in some conglomerates' corporate data sets, which is of course ironic because Disney's insistence of locking up their own IP behind these massive walls of copyright protection do their part to contribute that the cultural touchstones that we love and value are going to be owned by a handful of corporate conglomerates, But as I said before, you can be a hypocrite and still be on the right side of the law, and in this case, Disney does have a case. Fair use is meant for commentary, critique, and education, not to protect corporate tools that are meant to replace human creators. And while someone can make transformative work using Midjourney, Disney can and will argue that people are using these tools to usurp the market and create derivative works that are intentionally meant to fool people that they are official Disney products. In order for something to be protected under fair use, there needs to be a transformative quality about it. And US courts have done a really good job of protecting these cases, especially when they derive a new meaning, add a new voice, or create a new commentary from it. But this defense is often misused and abused. And there's a fine line here, because if I take a Taylor Swift song and keep the same melody, and I just change the lyrics to make them a little bit raunchier for shock value, that's not gonna hold up. But if I take that same song and turn it into a punk rock album, criticizing or commenting on the fabricated emotion of modern pop music, there's a good chance I can get away with it, even if eventually I'll be bankrupted into ruin from the eventual lawsuits that Mrs. Swift would, Miss Swift, I should say, would send my way, because in this country, once again, you can just bully people into submission with endless legal fees, but legally, I would still be in the right. Future me here, because I'm editing this video and I realize that I regret not including one of the largest landmark copyright cases of the internet era, and one that some of you are probably already familiar with, and it concerns the song of the summer in 2013, Blurred Lines by Robin Thicke and Pharrell Williams, which was a shameless celebration, an intentional homage to Marvin Gaye. They were intentionally trying to make a song with the same vibe and energy as Gaye's Got to Give It Up. But they were careful to avoid repeating any of the lyrics, using any of the melodies, chord progressions, and they didn't sample any of the original song. So you would think this would be a slam dunk, fair use, protected case, right? Well, they were sued by the estate of Marvin Gaye, and they lost. They were found guilty of, quote, copying the overall feel and sound, or what's often referred to in music as the groove, instrumentation, and stylistic elements. Blurred Lines mimics the funky rhythm using similar percussion loops, laid-back drum tracks, and cowbell-driven bouncing grooves. While not identical, Blurred Lines' bass line has a very similar contour and bounce, even if the actual notes are different. Both songs feature a high-pitched falsetto, with Robin Thicke doing his best to imitate the energy and tone of the original. But again, they didn't use any of the same lyrics, nor the same melody. But the court agreed that the constellation of elements resulted in something that felt too much like a Marvin Gaye song, even though nobody can point to a single stolen bar of music. Essentially, Robin Thicke and Pharrell Williams made a near-perfect derivative of a Marvin Gaye song without being Marvin Gaye. They intentionally made something that the general public could reasonably confuse as a Marvin Gaye song. Somebody could say like, damn, this feels like Marvin Gaye's music. And the court determined that it was a direct competitor, and ultimately, from a legal standpoint, that's kind of where they dug their grave. If they had made something that commented on Gaye's music, or was a parody of the genre, or something like the earlier example I gave, turning Taylor Swift into a punk rock ballad against the false emotions of pop music, they probably would have gotten away with it. Now, this decision was controversial because nobody on the jury was any kind of musical expert, and certainly neither was the judge. Critics say that the ruling was made based off of emotion rather than any kind of sound musical theory, but the court ruled that enough protectable elements were used. And ultimately, that is the fine line between influence and infringement. And if you're still not clear on the matter, don't feel bad. This can be confusing as shit, especially because in most cases, a vibe is not something you can copyright. If you want an example of the right way to do influence, let's take a look at The Killer's second studio album in 2006, Sam's Town, which is a shameless celebration of all things Bruce Springsteen, and a personal favorite of mine because I love Springsteen. He's one of my favorite artists. And if you listen to that album, there is no mistake that the boss's music is a heavy influence on it. It could reasonably fit into his catalog of music if Brandon Flowers didn't sound so unique in his voice. It is a stylistic homage, similar in themes, vocal delivery, arrangements, but it steers clear of being too similar to Springsteen's more protectable elements. That one's a mouthful. Ultimately, Sam's Town doesn't feel like it's trying to replace Bruce Springsteen on the radio, even though it sounds a hell of a lot like Bruce Springsteen, whereas Blurred Lines was the mega hit of 2013 precisely because it felt like a Marvin Gaye song. And I know that sounds like a distinction without a difference, but it just goes to show you, if you're going to borrow anything from something that's already out there, something that's protectable, you gotta add your own spin to it. You gotta add some kind of commentary to it. Otherwise, prepare to pay some royalties. To repeat a quote from the case that I referred to earlier from The Nation magazine regarding former President Ford's memoirs, to negate fair use, one need only to show that if the challenged use should become widespread, it would adversely affect the potential market for the original. The court determined that Blurred Lines was a direct competitor to Marvin Gaye's catalog. And it probably didn't help that Pharrell Williams himself literally said, quote, "We are trying to do a Marvin Gaye thing." So I guess if you're gonna commit copyright infringement, don't brag about it. And now, back to the rest of the lesson. Midjourney claims that their outputs are not exact duplicates, but rather original combinations inspired by their training data, and that is baloney. Studies and anecdotal evidence by anyone who's ever used Midjourney show that you can prompt exact replicas and duplicates of these beloved characters. And I'm sorry, but that is not transformative, that is a clone. 2, they trained on copyrighted data without consent, and this alone might be enough to trigger an infringement liability. No attribution, no licensing. AI companies have profited from copyrighted content without compensating, crediting, or even acknowledging the artists whose work have enabled it. And this brings us to our next hot lump of coal in this massive burning dumpster fire of intellectual property. AI generators like Midjourney consume millions and millions of terabytes of data without consent. And part of Midjourney's defense is that they do not reproduce the original works, that their model learns patterns but doesn't copy. Essentially, their defense is, I read 1,000 books and then I learned how to write and made my own novel inspired by what I've learned. And this brings us to another philosophical question that I doubt anyone's gonna have an answer for by the end of this video, though I'm gonna try. It's impossible to find a piece of art that hasn't been inspired, influenced, or borrowed elements by the things that came before it. Quentin Tarantino's films borrow heavily from other filmmakers such as Sergio Leone and Akira Kurosawa, who in turn borrowed things from John Ford and William Shakespeare, who in turn used history and other people's mythologies to create his own original plays, and on the cycle repeats itself. The evolution of art follows a linear process: mimicking, mastering, and mutation. If I learn how to draw Spider-Man, for example, by reading my favorite comic books from Spider-Man and copying them meticulously over and over again, and then years later I grow up and I become a comic book writer in my own right, and I develop my own comic books with my own characters, my own original stories, setting, etc. But it is clear that my work is inspired by Stan Lee and Steve Ditko. No one's gonna have a problem with that. I think we all agree that everybody's art is influenced by something, but then it eventually is shaped by our own unique individual experiences and inspirations. So why is it different if an algorithm does it? And to answer that, let's propose some other questions. Do you copy more than what you transform? And I think judging by what's made in Midjourney, I can say the answer is yes. Do you present someone else's artistic expression as your own? I think many of these AI artists are doing exactly that. If you create derivative works that are intentionally indistinguishable in style, aesthetic, tone, and market purpose from the original, I mean, fuck yeah, like just look at how much AI slop is on Etsy right now. Like the whole point is to create outputs that look exactly or as close to like Mickey Mouse so that you can slap it on a mug and sell more mugs. Nobody's putting Mickey Mouse on shit just because he's cute. Like they're doing it because people are more likely to buy things with Mickey Mouse on it because people love Disney. They're not trying to transform it. They're not trying to lend their own unique individual voice. They're not making a commentary on it. They're not trying to hold a mirror to the world or reflect society's values back at them, you know, like actual fucking art. They're just ripping off Disney to make a buck. Going back to Quentin Tarantino, yes, his work is referential in style, but it is very transformative in the commentary that he's making on the world. Kurosawa's Throne of Blood is essentially Macbeth in samurai armor, and yes, he borrows the plot from Shakespeare, but in the process, he created his own unique original cinematic language that people still refer to and emulate to this day. In my comic book example, it would have taken you years to transition from mimicking to mastering to mutation. You'd have spent thousands of hours consuming comic books, drawing panels, studying them, recreating, studying shades and texture and color and shadows, practicing your outputs over and over again just to be decent enough to make a Spider-Man drawing that is indistinguishable from what you see on the page. It would be unreasonable and unrealistic to expect you in that same amount of time to write like Ernest Hemingway, design homes like John Lautner, and paint in cubism like Pablo Picasso. AI trains on billions of potential outputs of art, and it can do it in seconds, and it does it without consent. Humans simply cannot replicate that. It's an explosion of scale that simply does not deserve the same level of copyright protection as earned human creativity. And finally, monetizing your artistic journey does not come at the expense of the artist that inspired you. Quentin Tarantino's job security is not going to be on the line because I made a film with action sequences inspired by Kill Bill. These AI companies are making billions. They've become billion-dollar companies by scraping your portfolio with the sole purpose and intention of fucking replacing you. If that's not market disruption, I don't know what is. Midjourney also claims they're not liable for any infringing because they themselves don't actually make anything. It's the users that do. Oh yes, the whole I'm just a platform, blame the users, I can't control what they do card. Napster already tried to play that and they lost. And look, sure, having AI write a novel in the style of Ernest Hemingway that takes place in feudal Japan is technically transformative, right? Legally, you're probably in the clear. But why does that still feel fucking dirty? I'll tell you why. There's no emotional barometer to refer to when trying to justify your character's motivations. There's no sacrifice. There's no weeping late at night over a bottle of whiskey because it's so fucking hard and the algorithm fucking sucks and you're this close to just fucking quitting and getting a regular job. It's just a machine wearing Hemingway's skin, a literary deep fake.